7.
Live streaming.
P1 Naptalu appearing together with Team FIM07, P2 Mbira from the prosecutor's office in the matter prosecutor versus Aduga Bolo. Your Excellencies, we intend to use 30 minutes of this court's time. I shall use 14 minutes for issue 1, and Michael Agent shall use 16 minutes for issue 2, 3, prayers, and we shall reserve 5 minutes for Sari battles. Your Excellencies, if this gives a clear roadmap to this honorable court, I beg to proceed with the facts of this matter. Your Excellencies, Aduga Bolo is a citizen of Chuma and is the co-founder of Chu Liberation Movement. Your Excellencies, it's believed that he financed the attack of the civilian Zenjian aircraft that led to death of 298 passengers. But before that, in February 2018, CLA attacked a hospital in a barrage that led to death of 8 wounded soldiers and 10 children. And in April 2018, CLA attacked and raped women of Funani region. In July 2018, CLA attacked 2 military camps of Zenjin and also attacked the headquarters of the Red Cross to steal vehicles and other materials there. Your Excellencies, it's from there that Aduga Bolo was arrested and charged by the criminal court of Kobole, and he was acquitted. From his acquittal, he seriously solicited for funds to fund the MLC and CLA, and from there he was arrested by the African Court of Justice. Your Excellencies, as earlier noted, I shall handle issue 1, which states whether this case, prosecutor versus Aduga Bolo, is admissible before this honorable court. Your Excellencies, I intend to divide issue 1 into 2 limbs. Limb 1, admissibility, limb 1, jurisdiction, and 2, admissibility of this matter. Your Excellencies, the preamble of the Malabo Protocol and Article 18 of the Vienna Convention of Law of Treaties of 1969 provide that states shall not refrain.
Counsel, what kind of source of international law is the convention you just mentioned?
I beg your pardon, Your Excellency.
What kind of source in international law is the Vienna Convention that you just mentioned?
It's a treaty, Your Excellency. It's Article 18 of the Vienna Convention of the Law of Treaties of 1969, which provides that states should refrain from acts that breach the purpose of the treaty. Your Excellencies, pursuant to paragraph 1 of the facts, Chuma and Zenyin State are both members of the African Union and United Nations, and both ratified the Malabo Protocol and the 1999 Convention on Suppression of Financing of Terrorism. Your Excellencies, pursuant to Article 28 of the Malabo Protocol, it gives jurisdiction to this honorable court to handle any legal disputes that is submitted to it. Your Excellencies, since Aduga Bolo grossly violated human rights in the state of Zenjin, this court cannot hesitate to handle this matter. Your Excellencies, jurisdiction is classified into three kinds of this jurisdiction. 1, jurisdiction personnel, jurisdiction temporary, and jurisdiction material. Your Excellencies, Article 46E, Clause B of the Malabo Protocol provides for temporary jurisdiction, and it provides that if states are ratified to the Malabo Protocol and the protocol is already in existence, they can proceed or they have temporary jurisdiction in this honorable court. Your Excellencies, Article 46E, B, Clause A of the Malabo Protocol provides personal jurisdiction to this honorable court since the states of Chuma and Zenjin are ratified pursuant to paragraph 1 of the facts. So this court has personal jurisdiction to handle this matter. Furthermore, Excellencies, immunity as provided under
Counsel,
paragraph.
can I address a question? Am I audible? Am I audible? Yeah.
Yes,
Counsel,
yes, yes.
yeah. Can I address a question? The jurisdiction of the court is human right, according to you, and it's relevant to which fact that actually what the defendant has violated is the human right violation. Would you like to report on the fact that is the defendant, that Mr. Bolo, is violating a human right?
Much obliged, Your Excellency. Your Excellency, question to paragraph 4 of the facts. Hospital in Aberaj was attacked by CLA that led to death of 800 soldiers and 10 children. Question to paragraph 5 of the facts. Women of Funani region were raped and other war crimes as evidence in paragraphs 4, 5, and 6 of the facts. And the right to life was violated, the right to liberty was violated, and the right to property was violated, Your Excellency. Your Excellency, proceeding on the admissibility of
But
on being.
counsel, I have a question first. And what about the non-bis in idem principle? Because I believe that according to the facts, he has already been judged by a criminal court, by a national criminal court. Then by judging us, the African Court of Justice, don't we are not in violation of the non-bis in idem principle?
Much obliged, Your Excellency. Your Excellency, this court has Your Excellency, the African Court, pursuant to Article 46, Clause I, Article 46I, Clause 2 of the Malabo Protocol, provides the non-bis idem principle that if there was shielding of the criminal responsibilities of any state authority, this case or this court can handle the same matter if the national court was not independent or was not impartial due to maybe due to head or due to executive or legislative influence. Excellence. Furthermore, this case
But
has
but
sufficient.
counsel, can you show us how you how this national criminal court was not impartial or did not fulfill the requirements you just mentioned?
Much obliged, Your Excellency. Your Excellency, pursuant to paragraph 8 of the facts, Aduga Bolo was a Minister of Defense in the state of Chuma. Not only that, Your Excellency, he was a brother-in-law to the President of Chuma. Your Excellency, the pursuant to paragraph 16, the 2.5 hour that was given to the court to proceed for a matter that involved gross violation of human rights, where children were killed, women were raped, who are innocent, Your Excellency. And the criminal court, the National Criminal Court of Kobole, acquitted free Aduga Bolo, Your Excellency, because of the shielding or the influence that Aduga Bolo had in the national court. That's why we are back to this honorable court. Your Excellency,
Council, just a minute. Regarding in the 2 hours 30 minutes, my understanding would be that in the 2 hours 30 minutes you had no sufficient evidence, and the evidence that you had produced before the court is that to do with ESA. I mean, if you have you only have ESA evidence, why would it even take you so much time? Because the reason why they acquitted Adu Gobolo is because you didn't have sufficient evidence. Would you make a comment on that? Or rather, is there a specific law that stipulates that a matter should take a specific period of time?
yet, much obliged, Your Excellency. Your Excellency, ordinarily there is no law, whether national or international, that provides that proceedings are supposed to take or stipulated a given period of time. But, Your Excellency, question to this very issue, the 2.5 hours were not enough for someone who had violated human rights, for someone who had grossly killed children, someone who had raped women who are innocent. That time was really not enough for this court, for the national court to handle such a matter.
Counsel,
Furthermore,
my question, Counsel, just a minute. My question is on the evidence that you are relying on. The evidence presented before this honorable court, as you have highlighted paragraph, 5 different paragraphs, but all the paragraphs that I'm looking at are based on ESA, are based on reports. So what would be your argument? Because you're saying there are violations, and if you look at the evidence that has been produced before the court, it starts to do with hearsay.
And I like to add something else to that question, which is that the reason what the criminal court, the National Criminal Court, declared that he was innocent was because there wasn't any proof beyond a reasonable doubt.
much obliged, Your Excellency. Your Excellency, pursuant to the case prosecutor versus Jermaine Katanga and another, a situation in the Democratic Republic of Congo, in the pretrial chamber of the ICC, court held that hearsay evidence can be admissible if it has probative value, if it is credible, if it is sufficient. Your Excellency, in this matter, evidence that was got from different NGOs like Ginica had gravity. Furthermore, Excellency, lastly, this case has sufficient gravity.
I'm sorry. Let me interrupt you again. Do you have, or can you quote any case law in which reports from an NGO has been used in order to declare the criminal responsibility of an individual? Has that happened in any other cases?
Much obliged, Your Excellency. Your Excellency, the case prosecutor versus Jermaine Katanga and another, a situation in the Republic of Congo. In that case, court relied on evidence from different NGOs that were situated in the Democratic Republic of Congo, and that evidence was admissible. So the same applies to this case, Your Excellencies. This case can be admissible based on hearsay evidence and also evidence from different documents that were made by different NGOs. Your Excellency, this case has enough gravity. Your Excellency, pursuant to paragraph 4, 5, 6, and 7 of the facts, gross atrocity, war crimes happened in Zenjin region from CLA, where children were killed, wounded soldiers were attacked, and that is enough scale to have gravity or to give gravity to this case. Excellency, pursuant to paragraph 11 of the facts, these war crimes led to social alarm at the international level, whereby the Peace and Security Council of the African Union had to send the prosecutor to Zenjin region to take part or to make investigations on the different war crimes that had occurred in Zenjin that had led to loss of millions and millions.
Can I interrupt a second? So when you underline the war crime and in your argument, it means that there is a war happen in that situation. Is it right? Right? Is it an armed conflict happen in that situation?
Much obliged, Your Excellency. Your Excellency, pursuant to the facts, under paragraph 4, a hospital in Aberash was attacked. Paragraph 5, women were raped. Your Excellency, pursuant to Article 28D of the Malabo Protocol, it provides different war crimes that amount to a non-international armed conflict. Which war crimes occurred in the state of Zenjin? Your
So,
Excellency?
Counsel, you mentioned about international armed conflict. Would you like to inform the court the element of armed conflict, international armed conflict, according to, for example, Geneva Convention? Are you familiar with Geneva Convention regarding the element of the armed conflict, international armed conflict?
Yes, Your Excellency.
Yes. Would you
Your
inform?
Excellency.
Yes. Yes. Proceed. Yes.
Your Excellency, this was a non-international armed conflict pursuant to Article 1 of the Geneva Convention, and also,
Agent,
Article 1 of Additional
Council,
Protocol 2
of which Geneva
and
Convention?
Article 3 of the Geneva Conventions.
Which one?
Which one?
Which
Council,
one?
I'm sorry, which one?
Article 3, common to the Geneva Conventions of 1969 and Additional Protocol 2 of 1977.
And why do you classify that conflict as a non-international armed conflict? What are the requirements for a non-international armed conflict to exist, and how are they fulfilled in the present case?
Much of that, Your Excellency. Your Excellency, that was a non-international armed conflict, and that is according to the ICTY case prosecutor versus study, whereby a non-international armed conflict was defined as a conflict that is between a state and organized groups. So in this matter, the armed conflict was between Zenjin and an organized group that is CLA that was led by Mr. Adugabolo.
Okay. Would you like to clarify what kind of organization is CLA?
Your Excellency, it's a non-state group, armed group. Your Excellency, I pray to submit and call my co-agent to proceed with issue 2.
Okay.
May it please court. Good afternoon, Your Excellencies. This is Team 07 Prosecutor 2, Mbira. Your Excellencies, I'm going to make submissions as per issues 2 and 3 for the prosecution, and thereafter make prayers, Your Excellencies. Your Excellencies, proceeding on to issue 2 of my submission, I pray to handle issue 2 in 2 limbs of argument. The first limb of argument is that the conflict between the Zengin state and the Chu Liberation Army amounts to a non-international armed conflict. My second limb of argument will be that the CLA under the command of Kaduga Bolo intentionally carried out attacks on protected persons and protected property. Your Excellencies, proceeding on to my first limb of argument, which says that the conflict between the Zengin state and the Chu Liberation Army amounts to a non-international conflict. Your Excellencies, it is prudent to note before this honorable court the definition plus accounts for an armed conflict. Your Excellencies, in the matter prosecutor versus Dusko Tadic of 1996, at paragraph 70, before the International Criminal Tribunal of the former Yugoslavia, court reasoned that an armed conflict exists whenever there is a resort to force between protracted and violence between government authorities and armed groups. In the same case, court highlighted on the elements of an armed conflict.
Yes, and how, as you said, that needs to be protracted. How that specific requirement is met in the present case, that protected.
Much obliged, Your Excellencies. Looking at the 2 elements of an armed conflict, the first one being violence and the second one being protracted attacks. Protracted attacks, it means that these attacks were not just carried out in a single day or in a single year, but these attacks went on in a given period of time. Your Excellencies, looking at the facts of the case before the scenario court, as highlighted in paragraph 4, we see that the CLA carried out an attack on the hospital in a burst that led to the death of 800 soldiers and 10 innocent civilian children that were not taking part in hostilities. We also see an attack on the women of the cult of Funani, as highlighted in paragraph 5, still by the CLA, that was under the command of Aduga Bolo, that brought about the rape of women, that brought about the detention of women. Your Excellencies, as also highlighted in paragraph 6, still the CLA that was under the command of Aduga Bolo carried out attacks.
Under Council? Yes, you're right about fact 4. However, it's believed that that hospital recently served as a secret annex to the military camp. Then that does not change what you're just saying?
Much obliged, Your Excellency. Your Excellency, looking at the principle of necessity, looking at the principles of distinction, looking at the principle of proportionality, was it necessary for the CLA to attack this hospital in Abaras and lead to the death of 800 soldiers that were not taking part in hostilities? Was it necessary for the CLA under the command of Aduga Bolo to attack the hospital and bring about the death of 10 innocent children that were at no point of time taking part in hostilities? Was it really necessary? And did really the Chile Liberation Army distinguish that this was a civilian medical unit? Because the people that were killed there were not at any point of time taking part in hostilities. Therefore, Your Excellencies, it was not prudent for the CLA to attack this hospital and kill innocent people that were not taking part in hostilities, Your Excellencies.
Council, another question. Can you provide this court with any other case law regarding children? Has any other international tribunal said something about children, especially in hospitals, maybe when they're civilians?
Much obliged, Your Excellencies. Your Excellencies, looking at the matter, the prosecutor versus Dominic Ongwen, before the International Criminal Court, it is to be highlighted that Dominic Ongwen was held liable for the atrocities that he committed on the innocent children. First and foremost, he attacked innocent children that were being treated in hospital, and he forcefully conscripted them in the LRA. Therefore, Dominic Ongwen was held liable for the atrocities committed on the children. They were denied and their right to life was violated, Your Excellencies, which is the same in this honorable court. Aduga Bolo, on the attack of the hospital in Abraj, led to the death of 10 innocent children that were not taking part in hostilities, Your Excellencies. Your Excellencies, it is prudent and to be noted by the prosecution that this is a non-international conflict as defined in Article 1 of the Additional Protocols 2, 1977, that a non-international conflict is a conflict between state-organized armed forces and non-state organized forces. Your Excellencies, this was a conflict between the army of Zengin and the CLA. Even if it is evident in the fact that the CLA bases in the Chuma state, it is not highlighted earlier that the Chuma as a state gets involved in the activities of the CLA, hence qualifying the CLA to be a non-state armed group, Your Excellencies. And looking at the two principles, the threshold of organization and the threshold of intensity, as highlighted in the textbook International Humanitarian Law by Niels Melzer at pages 68 to 70, it was highlighted that there are two principles of a non-international conflict: threshold of organization and threshold of intensity. Looking at threshold of organization, there is need to look at the command structure that exists in the armed group. Your Excellencies, it is prudent, as noted in paragraph 5, Aduga Bolo is the direct leader of the CLA. The reason as to why Kifel Deno writes a letter to Aduga Bolo is because he gets commands from Aduga Bolo. Your Excellencies, hence existence of a command structure. Highlighting in paragraph 9, it is not that the Article 12 of the MLC statutes gave Aduga Bolo broad powers that extend to acquisition and distribution of arms. Which way it is the prosecutor's submission that Aduga Bolo uses the same responsibility to support the CLA, not only financially, but also by soliciting for them military weapons that they use to execute their duties, to execute the atrocities they commit, Your Excellency.
Council.
Yes, Your Excellency.
I have a question under paragraph 5. You say Aduga Bolo is a direct leader, but the same facts, line 5, it says
Yes,
it says that release. Okay, let me just go back. A few days later, this is an NGO disseminating classified documents from anonymous source released a report from a CLA commander, Kifile Dineo. So my understanding from those facts is that the commander of the CAL is Kifile Dineo and not Adugo Bolo. And if Adugo Bolo was to be maybe affiliated with the CAL, my understanding would be he may be maybe just a superior person that is just giving instructions that cannot really make him to be a commander, because the facts are clear that Kifelo Dineo is the commander of the CAL. So why are you bringing Adugo Bolo to court instead of Dineo?
Much obliged, Your Excellencies. Your Excellencies, The fact that it is highlighted in paragraph 5 that Kifelo de Neo is the command of the CLA, but it is the prosecution submission that the reason as to why Kifelo de Neo writes a letter to Aduga Bolo informing him of the atrocities of the CLA in Zengid, it is because Aduga Bolo, it is because Kifelo de Neo gets commands and orders from Aduga Bolo. Excellencies, if Aduga Bolo did not have command responsibility, then he wouldn't have commanded the shooting of the airline's Vision 22 that led to the death of 298 civilians that were not taking part in hostilities, as highlighted in paragraph 10. But this exists between because Aduga Bolo has command responsibility over the CLA. Excellencies, if that serves your purpose, I pray to proceed. Much obliged, Excellencies.
Can you provide this court again, maybe some case law in which this a similar scenario regarding common responsibility has happened?
Much obliged, Your Excellencies. Your Excellencies, in the matter the prosecutor versus Celebic of 1995, before the International Criminal Tribunal of the former Yugoslavia, court highlighted that there are two elements of command responsibility, hence effective control. The first one, that proof that the accused person has ability to issue orders, and then two, proof that actually the orders have been executed that have been proved by the accused person. Your Excellencies, it is highlighted in paragraph 10 of the facts before the Honorable Court that Aduga Bolo placed an order that ordered for the shooting of the airline's Vision 22 that led to the death of 498 passengers. In the same facts of the case before the Honorable Court as highlighted in paragraph 7, the CLA under the command. Yes, Your Excellency.
Paragraph 10 that you're relying on is saying some observers believe Adugo Bolo. So it's just someone's opinion, believing that it may be Adugo Bolo or it may not. So how do you make conclusive arguments based on someone's opinion?
Much obliged, Your Excellencies. It is straight law as held in the matter, prosecutor versus Jermaine Katanga, that where there is no direct evidence, circumstantial evidence and hearsay evidence can be relied on as long as it is sufficient, credible, reliable, and regional. Your Excellencies, this is collaborated with the provision of paragraph 17, where even after Aduga Bolo being acquitted by the National Court in Kobole, he goes ahead to seek support from potential investors to fund the activities of the CLA and the MLC that brought about the gross violation of human rights that led to the death of 10 innocent civilians that are not taking part in hostilities, that brought about the death of 800 soldiers that are no longer participating in hostilities, that brought about the attack of the ICRC headquarters, a neutral body, a neutral organization that does not get involved in the conflict between the Zengin and the CLA. Therefore, Your Excellencies, proceeding on to issue 3 of my argument, which states that Aduga Bolo is affiliated, connected, and financed the activities of the CLA. Your Excellencies, I will handle this issue based on the principle of effective control, as it was held in the matter prosecutor versus Selegic in 1995 before the International Criminal Tribunal of the former Yugoslavia. Court held that proving the principle of effective control, the prosecution has to look at 2 elements. The first element, capacity of the accused person to issue orders. The second element, that actually the orders of the accused person are executed. Your Excellencies, that is highlighted in paragraph 5. Aduga Bolo is the direct leader of the CLA, as it is highlighted in paragraph 17. Even after Aduga Bolo being acquitted by the National Court, he went ahead to seek for support from potential investors. Aduga Bolo would not have done this if he was not affiliated to the CLA. And that is even highlighted in paragraph 7, that even after Aduga Bolo issuing this command, actually the airline's Vision was attacked. That led to the death of 298 civilians that were not taking part in hostilities. Therefore, Your Excellencies, it is the prosecution's submission that basing on the sufficient and probative value evidence that has been submitted, that is credible, that is regular, that is relevant, and that has authenticity before this Honorable Court. First and foremost, this Honorable Court confirms the charges against the accused person Aduga Bolo, and hence this matter proceeds on to trial. I beg to submit, Your Excellencies.
Counsel, I'm sorry, just one last question. What do we do about immunities? Does Aduga Bolo has any immunities?
Much obliged, Your Excellencies. Your Excellencies, it is straight law that even when a person has state, national, or whatever, state, national, or political immunity, if that person has been brought before this Honorable Court, Your Excellencies, yes, even if Aduga Bolo has immunity, but this immunity should be done away with it, because the very person that has immunity is the very person that ordered for the gross violation of human rights that led to the death of innocent civilians, that led to the destruction of ISRS headquarters, that led to the destruction of the airline's vision. Therefore, Excellencies, even if Aduga Bolo has immunity, this immunity should be brought and should not be regarded before the Honorable Court, as it was held in the matter, in the case the prosecutor versus Omar al-Bashir in Sudan, where al-Bashir had immunity. But given the fact that he had committed atrocities that were a gross violation of human rights, court had to disregard the immunity. Because a person like Aduga Bolo should be a leader. This is a leader, he should act as an example. He knows to what Chuma as a state ratified to. Chuma ratified to the African Charter on Human and People's Rights, but the commands of the CLA that he commanded promoted a gross violation, atrocities that were against human rights, Excellencies. There's a violation to a right to life, a right to liberty, a right to privacy, a right to medical health whatsoever, Your Excellencies. Therefore, it is the prosecutor's submission that Aduga Bolo is affiliated to the CLA and he should be held liable for the same, Excellencies. I beg to submit.
Maybe well, Council, before you go, just a minute. You've argued human rights violation, but paragraph 17 also reveals that Aduga Bolo was placed in cells where he remained for 6 hours without eating and without speaking to a lawyer. Don't you think that is also a violation of Aduga's rights? So how do you come to court asking for talking about violation of human rights and yet you violated his rights as well?
Council,
I'm sorry, your time is up, but for you to answer that question, you have an extra minute that will also give the other team. So you have 1 minute to answer that question.
Much obliged, Your Excellency. Your Excellencies, we as the prosecution, we are not in contention that maybe at one time Aduga Bolo's rights were violated. But there is a maxim of equity which provides that equity aids the vigilant. Your Excellencies, we are not in contention that Aduga Bolo's at one time his rights were violated, but this case has been brought by the prosecution because Aduga Bolo violated the rights of the people in Zengin. Therefore, it is the prosecution's ambition that if Aduga Bolo also feels that at one point of time his rights were violated, equity aids the vigilant, he can also come to the same court and he can submit in his matter that his rights were violated. But we as the prosecution pray that this Honorable Court bases on the proceeding that the prosecution has brought before the Honorable Court, because it is on the grounds that the very person, because if you seek equity, you must seek equity with clean hands. But Aduga Bolo also went ahead to violate the human rights or in the people in the territory of Zengin. Therefore, on grounds that equity aids the vigilant, it is the prosecution that has adduced this case before this court, and therefore we pray that this Honorable Court gets concerned with the case that the prosecution has adduced before this Honorable Court. I pray to submit, Your Excellencies.
Thank you, Counsel.
Welcome.
So, if defense is ready.
Yes, Your Honor. Good afternoon, Judge. Good afternoon, Judge, and all the members of the Honorable Court. May I please the court? My name is Councillor Hawi Wayo for the defense of prosecution, along with my co-counsellor Lydia Desalegn. Your Honor, with the permission of the court, we would like to allocate our time as follows. I will use the first 10 minutes to address the inadmissibility of the charge and the jurisdiction matter as well. My co-counsellor Lydia Desalegn will use the next 20 minutes to defend the prosecution of a war crime and the command responsibility defense. Finally, with the permission of the court, we would like to reserve 5 minutes for sub-rebuttal. May I proceed, Your Honor?
Yes, please.
Thank you. Your Honor, regarding the jurisdiction, the International Criminal Law section of the African Court of Justice and Human Rights has no jurisdiction over the matter because pursuant to Article 28 of the Protocol on the Statute of African Court of Justice and Human Rights, the court is not given clearly to have a criminal jurisdiction over the criminal matters, which is impossible to assume criminal jurisdiction over criminal matters in a place it is not clearly provided under the protocol. Your Honor, pursuant to Article 46E of the Protocol on the Statute of African Court of Justice and Human Rights, the court will have a jurisdiction if the protocol is enforced and the crime is committed after the protocol enter into enforcement, as per Article 9 of the Protocol on the Statute of African Court of Justice and Human Rights. In our case, the state of Zenjin, the state of Chuma, and the state of Pintu ratified the Malabo Protocol in order to assume a criminal jurisdiction over the matter. But it requires the Malabo Protocol to be enforced, which the enforcement of Malabo Protocol requires the minimum ratification of 15 states in order to assume a criminal jurisdiction. Your Honor, in our case, only 3 states have ratified the Malabo Protocol, that is the state of Chuma, the state of Bindu, and the state of Zenjin, as per paragraph 1, line 6 of the given case fact. So the minimum ratification requirement is not fulfilled to entertain this jurisdiction, which restricts the court to entertain its criminal jurisdiction over criminal matters. Even if we assume that the protocol is enforced, still the court lacks its criminal jurisdiction over criminal matters. Therefore, material jurisdiction is not fulfilled for the reason that the allegation or the alleged prosecution is contained in the Malabo Protocol, and the Malabo Protocol is not yet enforced. So the court will not have a criminal jurisdiction. Regarding the admissibility of the charge is inadmissible for the...
Counsel, I have a question first. What is the difference between jurisdiction and admissibility? Is there any difference between those things?
Yes, Your Honor, there is a difference between jurisdiction and admissibility. There is a circumstance where, in case there is no jurisdiction, we might not talk about admissibility. First, jurisdiction has to be established to talk about admissibility. So there is a difference between jurisdiction and admissibility. May I proceed, Your Honor?
And what is admissibility? I know that for admissibility to exist, there needs to be jurisdiction, but then what is jurisdiction and what is admissibility?
Jurisdiction is a competency of a court to entertain a matters before it, whereas admissibility is a requirement which a case requires to be seen by the courts. So their basis is different on the case. When we talk about the jurisdiction, we are talking about the competent court, whereas we are talking about admissibility, we are talking about the case or the substance. So they are different. May I proceed, Your Honor, with the admissibility issue?
Yes.
Thank you, Your Honor. Regarding the admissibility of the charge, it is inadmissible charge. We based on 4 bases. First, pursuant to Article 56, Sub 4 of the African Charter on Human and People's Rights, it clearly says that a communication that's exclusively based on the charges that obtained from mass media is inadmissible. Your Honor, in our case, as per paragraph 7 of the clarification of the fact, the charge is not well-founded both in fact and in law. The reports of the NGO human rights, as well, Masisi, as well as the information shared by the Guinea News Agency, were filed as evidence before the African Court of Justice and Human Rights. Thus, Guinea reporters and NGO disseminating classified documents from anonymous source is inadmissible as per paragraph 5 of the given case fact. Your Honor, because such reporters has to be supported by evidences, we shall not just admit every reporters before the Honorable Court. Therefore, such evidence...
Counsel, Madam President,
yes,
can
please proceed.
Counsel, you made arguments that the report should not be taken in as evidence. Do you have maybe case law to support that position, that the court should not adhere to? Your Honor. Any case law?
Yes, Your Honor. We can name that the ICTY's prosecutor versus Maltini case that ignores the report evidences by the base of their mere exclusive. We shall not based on their exclusive news, which are based from mass media, are inadmissible. And we can get this decision from the case between prosecutor versus Miltunovic case. May I proceed, Your Honor?
And Counsel, I have another question, because I believe there are international tribunals and international criminal tribunals that have accepted reports of an NGO as evidence. Then does those reports need to fulfill certain requirements in order for them to be admissible in a case? Do you know if those requirements exist, and if they do, which are they, and how are they met in the present case, or are they not met in the present case?
Thank you, Honor, for the question. But yeah, there might be a tribunals that may decide it on such issue, but we shall take the substances into issue. The observer status of the NGO might be established, and it might be different from state to state. So it doesn't mean we do not find a cases which might be made admissible in such issue. So as I am a defense, I will take a case that might help my defense. So I didn't mean that there is no cases that's taken on the basis of admissibility issue on the reports. May I proceed, Your Honor?
Yes, please.
Secondly, pursuant to Article 56, Sub 5 of the African Charter on Human and People's Rights, the charges has to be exhausted before exhausting local remedies before brought to this court. And in our case, as per paragraph 16, so one of the given case fact, the charge has not brought to other national courts rather than in appeal form, rather than just referring to the Charter Criminal Court. Even when you see in the case between Priscilla, Niger, Icharia versus Kenyan case, the African Commission referred to the requirement of exhaustion of legal remedy. To meet, the complainant must take his case or her case to the highest judicial authority in that state. But in our case, it is difficult to say any other options are taken, rather than just referring to the Charter Criminal Court. In other words, the rule requires that a recourse to ordinary courts must be exhausted first.
Counsel, just help me understand. Is the admissibility process in the African Court on Human and People's Rights the same as that of the African Court of Justice and Human Rights? Since you brought in the aspect of exhaustion of local remedies, maybe you can kindly guide the court on that.
I'm sorry, would you repeat it? I didn't hear your question.
My question is, you've invoked exhaustion of local remedies, which is a criteria in the African Court on Human and People's Rights. So
Yeah.
I'm asking, is it the same in the African Court of Justice and Human Rights? When we talk about admissibility, is it the same? Is it the same process, exhaustion of local remedies?
Thank you, Your Honor, for the question. Yes, Your Honor. Firstly, from the beginning, the concept of exhaustion of local remedy is giving a chance or giving an opportunity to solve the problems of a state by their own means. In a place, the defendant, or in a place the case is not solved locally, if we open the door to solve the cases regionally, it might will clash with the sovereignty matter. So first we have to solve the problems in a place or nationally. If we exhaust it, we may admit it to the regional courts, but in our case, we don't believe that it is locally exhausted case. May I proceed, Your Honor? Thirdly, Your Honor, pursuant to Article 56, Sub 7 of the Charter, no communication, Your Honor, no communication which already heard and decided by United Nations or African Union dispute settlement mechanism may be submitted to the court. In our case, Your Honor, we can say that the issue has been settled prior, which might result in double jeopardy. As per paragraph 16, line 1, we can see that Aduga Bollo has acquitted, even if he's prosecuted against war crimes. We can take that it is locally, this case is seen in local courts and decided that Mr. Aduga Bollo is acquitted. In such a place, looking this case in front of this court would result in a double jeopardy, which is bringing an individual for the same case in front of one court will result in double jeopardy principle. So, in base of this, this court.
But counsel, don't you think that it's a little suspicious that that decision was from a country that, given its context, maybe not be the most impartial country to decide the innocence of him? Do you think that national decision was impartial?
Thank you, Your Honor. It would be on the basis of evidence. We cannot say it's partial, it's partial. But if an individual have a presumption of innocence, but when we take this case in front of this court, it would contradict with the principle of double jeopardy. So rather than worrying for the partiality, making the case inadmissible would be greater to protect the principle of double jeopardy. May I proceed?
Yes.
Thank you. Thus, a conditions of admissibility that entails communication must not be dealt with the cases that have already been settled by the state involved is in accordance with the principles of United Nations Charter, the AU Charter, and the African Charter on Human and People's Rights. Therefore, at the fourth, Your Honor, as per Article 46A, sub 4 of the Malabo Protocol, the right of Aduga Bollo is violated, in which his mobile phone were deprived. He placed in the cell for 6 hours, Your Honor, for 6 hours, without eating, without drinking, even without being able to contact with his lawyer that can speak his language, which clearly violates the human rights protected internationally, Your Honor. Even, Your Honor, his computer was confiscated and his documents being examined without his consent. In this matter, how could it be a formal way to make admissible an evidence which got from this way? Therefore, the arrest and the detention of the commander is arbitrary, which shall be inadmissible. How does the court see these human rights violations? Shall we have to violate the human rights of others to protect the interests of the state? I don't think so, and we don't think so as a team. For all these reasons and failures to fulfill the elements of admissibility results in inadmissibility of a charge. And then we pray the Honorable Court to dismiss the charge and that the court does not have a jurisdiction over the matter. And my co-counsel Lydia Desani will proceed with the defense of war crime prosecution and the command responsibility. Thank you.
Good morning, Your Honors. My name is Lydia Desani. I'm a co-counselor for the defense team against the charges brought against the CLA and the command responsibility of Aduga Bollo. Your Honors, the defense team alleges that there was no war crime committed and Aduga Bollo has no subordinate superior criminal liability. Your Honors, from the beginning, the prosecution teams alleges that there was an attack against a protected building, which was the hospital, and that causes the civilians' population deaths. But, Your Honors, from the beginning, according to Rule 10 of the International Humanitarian Law, customary law, it says that when a protected building is alleged...
Can I address
Yes.
a question? You mentioned
Okay.
there is no war crimes committed in this present case, but according to the fact, there is a lot of casualty, yeah? And then, of course, the prosecutor mentioned about there is a conflict, an armed conflict indeed happened in the present case. Would you like to explain to the court that actually those facts is not it's not supporting your argument that there's no war crimes committed in this present case, and then you also mentioned about the national law based on your argument. Would you like to also mention which international law underline your argument?
Thank you, Your Honor. Yes, there was a conflict between CLA and the Zanjinian government. thus considered as a non-international armed conflict. And also there are these rules, and in this conflict the rules are applying from the international humanitarian customary laws and the additional protocol too. So we're basing our argument depending on these two laws. May I proceed, Your Honor? Okay, Your Honors, from the beginning, the hospital was not
And also,
protected.
sorry, if I understood correctly, you're also saying that there exists a non-international armed conflict.
Yes.
Okay, perfect.
Okay. Your Honors, from the beginning, the attack on the hospital already lost his protection, so the attack was just on the military object, according to Rule 10 of the International Humanitarian Customary Law.
But Counsel, what do we do about the children that are there?
Your Honor, I'm going to address that too. As I was saying that, according to our case, the hospital was used as a military annex, which making clearly a military objective. This can be defined according to Rule 8 of the International Humanitarian Customary Law, which says a military object is depending on their nature, location, purpose, or the uses. So we can see from this case that it was also used as a military object. According to the international...
Counsel, can I address the question? Can I just break in on it? You mentioned that the hospital in the present case is also one of military object, right? According to you, right? However,
yes.
in the international humanitarian law mentioned clearly that for example, hospital or school, church are not military objects that is actually protected under international humanitarian law. Yeah. Can you give an explanation why then you refer that the hospital is actually military object in this present?
Thank you, Your Honor, for raising this question. Yes, they are protected, even according to Article Rule 23, protected hospitals that dedicated a building to the hospital. But civilians objects or protected objects are not always protected. There are exceptions. So this hospital will fall under the exceptions of that make him a military object because of it was used as a military annex, according to paragraph 4 of the fact statement. This is why it become from the military object, it goes to, from a civilian object, it goes to the military object. We can see cases, according to the International Criminal Tribunal for the according to for the former Yugoslavians, according to ICT-wise, the prosecution versus Pavlik's case, if a building is used as a military object, it will loses its protected status. This is what happens in our case, which the hospital loses its protection, which is fell under the exception. Your Honors, according to the case, the military object will also have an advantage for the Tanzania's government in also distracting. This will have a really good advantage for the CLA. That's why the attack was in the beginning alleged. So, according to paragraph 3, line 3 of the fact statement, Tanzania's government was torturing, murdering, and kidnapping the officials of CLA. That could be planned at the military annex of the hospital. That's why our clients attack the hospital. That because we will get a military advantage from that. This is also necessary to attack. But as the prosecution team was saying, there was a civilians population death, but it was proportional and it was just a collateral damage. There was no clearly intention to attack civilians. There was children and the wounded combatants, but it was not an intention of the...
Yes. You're talking about collateral damage. It's
yes.
A hospital. Definitely in a hospital you find wounded soldiers, per se, I would say. And we're talking about 10 children that have been killed right now. Would your submission still stand that it was collateral damage? Bearing in mind that also principles of IHL where there's proportionality. Obviously, when you're attacking a hospital, in my mind, I'm thinking there should be some some limited force, while knowing that the people that are found in the hospital, those are people that obviously there should be civilians there, as well as civilian property, as much as it is a military object. Maybe you can just try to make a comment on that based
Thank
on
you,
your
Honor.
argument of
Okay,
collateral
thank you.
damage.
Okay, thank you, Your Honors. Yes, there was, we say that there was a proportionality and there was a collateral damage. We're saying this because of that even if there was a civilians population death, which was not an intention to, which was an intention from the CLS army, it was proportional because it was not excessive. It was just up to the maximum of necessary for the getting the military advantage. So the collateral damage depend on the excessiveness of the attack. But as we can see that there was no intention, and because of the, even if we can say that this was the fault of the Zanginians government, because of, according to Rule 23 of the International Humanitarian Law, it prohibits belligerantes to not put a military objective near to civilians population. So who is violating this rule is the Zanginian government by putting civilians population area a military annex, which can cause those, which causes the deaths of those children and the wounded peoples. This principle is respected in IHL rule. That's what was violated by the Nigerian government that make our attack proportional, because we have a military advantage, and also it was not excessive, and it is also proportional, which brings us to a collateral damage of the civilians object or civilians population. Even had it been the Zanginians government protectors or evacuators the civilians, we could not have been attacked a civilians population. So I will move on the next counters that are brought by the prosecution team. Your Honors, the second crimes were the crimes charges were on the rape, on taking hostage, and also the attack of the building of ICRC. Your Honors, the allegation or the charges from the prosecution team was just depending on the media reporters. Your Honors, the crime of rape, taking hostage and attacking an ICRC's building is not just a crime that will be make a conviction depending on just media reporters. Your Honors, according to this, we clearly allege that the media reporters should be submitted with another additional reporters or evidences, as my co-counselor was saying in the beginning, on the admissibility of the factors. And also, according to the ICTY's case between prosecutor versus Matulik, in case of where the reporters have not mentioned the number of the interviews, the number of the people who interviewed, the conditions, the time, the duration, it cannot be acceptable. As with the prosecution was alleged, and the Ginkas report was even no clue that how many people were interviewed and the conditions. Not only this, there was also an additional case by International Criminal Court, which is the prosecution versus Jean Perry on 2012, which says reports that are untested and allegations of a crime, which neither the defense team or the chamber cannot examine the witnesses. It cannot be accepted because the chamber or the defenses cannot examine the witness, and also it will even intervene the chamber's power. And the last count of the prosecution was the attack on the aircraft, which is Airline Vision 22 on July 6, 2019. Your Honors, from the beginning, the evidence was only depend on the prosecution's evidence, and also according to the ICTY's case between prosecutor versus Salboda Mislovic, the prosecutor were denied admissibility. Because of that, the prosecutor would collect evidences that could be hearsays. So depending on our case, the prosecutor's investigation was just depend on the probability. According to the facts, the statement, it was just a probability. And the most important part is that
let me interrupt you. There's been plenty reports. It's just not one. There has been multiple of them that they all confirm the same thing. And there's been international criminal tribunals that have accepted an NGO report for the case to be admissible. Then don't you think that if there's multiples, as they are from NGOs, and they are clearly stating a big situation that breaches international humanitarian law, then shouldn't we admit those?
Your Honors, yes, there are a lot of cases that could be accepted, but not every cases has to be accepted depending on these kinds of evidences. Your Honors, even if we say that the court admits these cases, according to the fact statement, the statements of the prosecution teams will just depend on the probability. And even when we come to the case of the attack on July 6th on the airlines attack, it was the prosecutor's conclusion was just only about where the missile was fired, not about who was the CLA, or is that the CLA or others. So it was only about the where the attack was alleged, not about who. As the prosecutor team
live streaming
as the prosecutor team alleges. But from the first, there was no superior subordinate relationship. According to the ICTY's case, prosecutor versus Blaski's case, in the case of to establish the doctrine of command responsibility, there should be a practical and effective command control. But in our case, Adugabo being the founder of MLC, or the Military Liberation Front of Two, or being that he is an official leader of the army, does not necessarily establish the effective control or the effective the superior subordinate relationship. Even if Adugabo had reluctantly abandoned that the CLA, and also he was given his power to his little brother. This is clearly shows that there was no effective control. There, according to the allegation, there was no place that he mentioned about ordering to attack any kind of the attacks was committed by the CLA. So we cannot establish this element depending by just presumption of the Kefledinos idea or other observers saying. So we clearly say that there was no effective control. And the second element is the Adugabo law has a reason or know about the commission. No, Your Honors, there was no way that Adugabo law has a reason to know the acts of the CLA. According to our case, a knowledge cannot be established just by mere fact, or that cannot be depend on the general duty, because accordingly, only if a specific information was in fact available to him, we can consider that as a knowledge, or he has a knowledge to the attacks. According to the case between the prosecutor versus...
Counsel, can I interrupt? You mentioned about he has a knowledge of the attack, right? Then actually, according to international law, that if he knows something about the attack, but he doesn't do anything in the capacity of as a leader, then of course he is responsible for the attack indirectly. Would you like to give argument in this context?
I'm sorry, Your Honors. I was just trying to say he has no reason to know, and he has no way of knowing that the attack was committed. That was my mistake, Your Honors. Shall I proceed?
Yeah. I think your time is up, but
okay.
Did you count the extra minute? I'm sorry, I'm talking to experts.
Okay, you can continue, Counsel. You can continue. I didn't realize the time is up. Yeah, you can continue.
Okay, Your Honor. So, according to the case, Adugabo law was monopolized by his ministerial function. He was never, he was being long when he goes to the Mapalo territory, and he was no knowledge about the fact. And also, from the third element, he takes the necessary and measures depending on his capacity. Your Honors, we did not expect to take reasonable and necessary measures beyond his capacity. Adugabo has little capacity to manage the CLA because there was no superior subordinate relationship. But even if he take responsibilities and he punished Kefledino and he tried to bring back the women that were abducted, so this shows that Adugabolo has even taken
Council,
measures. Yes, Your
Council,
Honor?
according to paragraph 9, in which capacity did Dugobolo demand for the release of the abducted girls and also um, the disciplining of Kifele Dineo? In what capacity was he acting?
Thank you, Your Honor.
The time is up, so you have like 30 seconds to answer
Okay.
that.
We can say that this is because of he was a really accepted leader before this attack. So it was not about the effective control relationship, but it was the acceptance that he got from his origin. That's why he was he got the chance to punish the Kefledino. Thank you, Your Honors.
Thank you, councils. We then will proceed with the rebuttal.
Much obliged, Your Excellencies. May it please quote, this is Team FIM 07, Prosecutor Tom Mbira. I'm here to make submissions as per the averments of the defense. Your Excellencies, first and foremost, it is prudent to note that actually the defense is not in contention that Adugabolo is affiliated to the CLA. Secondly, it is prudent to note that the defense is not in contention that Adugabolo commanded the activities of the CLA that promoted to the intentional attacks of protected persons and protected objects. Your Excellencies, the defense bases on Article 9 of the Malabo Protocol that talks about ratification of 15 member states before the African Court of Justice and Human Rights coming into force, has highlighted in paragraph 16. Paragraph 16 does not provide that Chuma, Zengin are the only states that have ratified. No. It provides that Chuma and Zengin are states that have ratified, meaning these are part of the 15 states that have ratified to the Malabo Protocol, and hence the African Court of Justice, the African Court of Justice and Human Rights is into force, Excellencies. Excellencies, the defense avers that the prosecution is basing on hearsay evidence and evidence from NGOs. Excellencies, it is clearly stated in the matter the prosecutor versus Jermaine Katanga and another before the ICC. Court reasoned out that where there is no use of direct evidence, circumstantial evidence and hearsay evidence can be used to bring out the intention, the knowledge, and the participation of the accused person in the commission of the crimes before the Scenario Court. It is prudent to note that actually the defense is not in contention that the CLA attacked protected persons and brought about death. Now, if the defense is not in contention that actually there are deaths, the defense is not in contention that there are attacks on a civilian medical unit, the defense is not in contention that there was attack on the ICRC headquarters, which evidence does the defense want us to adduce before the Scenario Court when it is evident and the defense itself avers that there's a gross violation of human rights, Excellencies? Excellencies, the defense talks about the threshold of accusation of local remedies. Excellencies, it is the prosecution's ambition in the matter Jawala versus Gambia before the African Commission of Human and People's Rights. Court highlighted on the three elements of exhaustion on the threshold of local remedies. The first one, that proof that actually the matter was brought before court. Proof that court made a judgment. And then three, proof that you were not satisfied with the judgment of the court. It is the prosecution's submission that actually we exhausted the local remedies, Excellencies. We first went to the National Court in Kobole. There was judgment that was made by the National Court, but the National Court was not impartial, Excellencies. The National Court based its verdict basing on the shielding, given on facts that first and foremost, Adugabolo is the former Minister of Defense as alleged in paragraph 9.
Am I the only one that lost him?
No, we lost him too.
Yeah, we lost him too.
But they're there.
Much obliged. Much obliged, Your Excellencies. Your Excellencies, the defense also avers that Adogabolo's rights were violated. Your Excellencies, it is the prosecution submission that looking at the maximum of equity aids the vigilant. The prosecution is before this honorable court because Adogabolo violated the human rights of people in Zengin. And therefore, it is the prosecution submission that if Adogabolo feels that his rights were also violated, then the onus is up to him to also bring his matter before the court with clarified jurisdiction. Therefore, it is the prosecution submission that the case bases on the case that has been adduced by the prosecution before this honorable court. Because Adogabolo himself, he is not coming to equity with clean hands. He's coming to equity claiming that his rights were violated, not putting it into consideration that actually Adogabolo violated people's rights to life, people's rights to liberty, people's rights to property. Therefore, Excellencies, it is the prosecution submission that Adogabolo violated human rights of the people in Zengin. Proceeding on, Your Excellencies, the defense avers that the attack of the military hospital in Aberash was a military necessity. Your Excellencies, looking at the principles of international humanitarian law, looking at the principle of necessity, was it necessary for the CLA to carry out attacks that led to the death of 10 civilian children that are not taking part in hostilities? These were potential presidents tomorrow. These were potential prosecutors tomorrow. Should really this honorable court look at the fact that the defense alleges that this was military necessity? Okay, if it was military necessity, why wasn't this attack directed on militants that were taking part in hostilities? Is it really necessary for the CLA to direct this attack on people that were not participating in hostilities, Your Excellencies? And looking at the principle of effective control test, Your Excellencies, Adogabolo is a direct leader as highlighted in paragraph 5, line 7. If Adogabolo did not have effective control over the CLA, then why would Adogabolo go ahead, even after being acquitted by the National Court in Kobole, to seek for support from potential investors? It is the prosecution submission that Adogabolo should be held criminally liable for the atrocities of the CLA that he commanded. I beg to submit, Your Excellencies.
Thank you, Counsel. And then we'll proceed with the sub-rebuttal, please.
Thank you, Honors. From the reports of the prosecution team, we allege that from the beginning, the present case did not fail under the exceptions of the local remedies. So we allege that there was still the prosecution has failed to take local remedies, to use local remedies. And also, according when it comes to the necessary elements, yes, there was necessary element. There was also collateral damage, and the prosecution team was alleging that the attacks was directly intentionally on the civilians population. This is clearly shown that from the circumstances that there was no direct attack against civilians anywhere. It was just attack on the hospital that was used as a military annex. This is a clear circumstance that we have no intention to directly attack children's, women's. But we can see that the Zanjinians government was the one who violates an attributes by putting a civilian population a military annex. So the crime or the violation was made by the Zanjinians government, not by the CLA. So this is clearly shown that we have no intention to attack, and also the violations and the precaution measures should have been taken by the Zanjinians government. The second is that they were saying that the rape, the taking hostage, and the ICRCs was evidences was just sufficient. No, Your Honors, we say that there is no clear circumstantial evidences in addition to the Ginkas or Massinzian's report. So as long as the prosecutor team has an evidence that was clearly established that there was a crime committed by CLA, this court cannot accept a subsidiary or just a mere media reporters. And also Adogabolo's detention or was clearly a violation of human rights, which is taking him arbitrarily. They could have used legal procedures like giving an arrest warrant or something like that, but they just go and arbitrarily violating a lot of human rights. And also they have been detaining him for 6 hours without food, a drink, or any other necessary things, including prosecutors or that he can lawyers that can understand his language. Your Honors, we allege that there was no intentional war crimes committed by CLA Army, and Adugabolo has no command responsibility. Thank you, Your Honors.
Thank you, Counsel. Well, thank all of you. We're going to go to the judge's room and deliberate, and then we'll be back for feedback, okay? So please stay here in the room. Thank you.
Okay, thank you, Your Honors.
Honorable Court is now adjourned. Counsel and spectators will please wait in the courtroom to allow the judges to go to their room to deliberate.